Coming up next, CityNet 30 takes you downtown for the weekly luncheon meeting of the City Club of Portland. Live weekly coverage of City Club is produced through the facilities of Portland Cable Access. Now we join the City Club for this week's program.
Good afternoon. I'm Harriet Watson, President of City Club, and it's my privilege to welcome you to today's Friday Forum. Before we begin with our formal program of this afternoon, there are a few announcements. Next Friday's program will feature a panel presentation on Portland's Community Court project featuring Judge Clifford Freeman, Multnomah County District Attorney Mike Schrunk, and community activist Richard Brown. It will be here at the Multnomah Athletic Club, and we cordially invite you to join us. Again, please note in your bulletins, both from last week and this current week, the registration form for our Fall After Work series, The Performing Arts Backstage. Space is limited, so if you're interested, please send in your registration form as soon as possible. City Club mourns the loss of another longtime member with the passing of Jim Norlin. Jim had been a member of the City Club since 1968 and participated in numerous research studies, including this year's Increasing Density in Portland report. As part of that committee, Jim was honored with the Research Award this year. The City Club extends our sympathies to his family and friends. Our member host today, seated at the head table, is Pauline Anderson, past president of the City Club and chair of the Domestic Violence in Oregon Research Report. She will ask the first question of our speaker. Following Pauline's question, we will open the program to questions from City Club members in the audience. Please line up behind the microphone even before Pauline is finished so that we have time for as many questions as possible. As always, please identify yourself as a City Club member and ask your question in 30 seconds or less. And the prompt will appear if you do not. Also, if you hand in a written question, if you would please be so kind as to sign your name. Broadcast of City Club programs this quarter is made possible in part by corporate underwriting from CH2M Hill, U.S. Bank, and Enterprise Rent-A-Car Foundation. As always, we are grateful for their ongoing support. Today, we are extremely fortunate to have Kathy Rodgers, President and Executive Director of the Now Legal Defense and Education Fund, with us to help us think both specifically and more broadly about the implications of the Supreme Court's recent decision striking down part of the 1994 Violence Against Women Act. I don't think it an overstatement to say that this is a very dramatic and historic time in the life of this nation. And I can think of few issues which speak so compellingly to the mission of the City Club, which is to inform its members and the community in public matters and to arouse in them a realization of the obligation of citizenship. The decision in the case that Ms. Rodgers argued before the court, as well as other recent Supreme Court decisions, significantly resculpt the country's environmental, economic, and social landscape. They're about civil rights, states' rights, the so-called new federalism, and the most fundamental issues relating to balance of power among the branches of government. The implications are both fascinating and fierce, and one of our challenges as members of City Club, regardless of our individual stance on the matters, is to persuade the broader community to care about these things and not to dismiss them as merely arcane or academic. For as we all know, these are real issues that affect all of us in very real ways, as individuals, families, and communities. And probably no one knows that better than today's speaker. Kathy Rodgers joined the now Legal Defense and Education Fund in 1995, and under her leadership, the organization has expanded in both size and scope, developing new programs in child care, violence against women, immigrant women, economic justice, and judicial education. A specialist in labor law, Ms. Rodgers is a graduate of Smith College and Columbia Law School. She was general counsel, vice president, and later acting president of Barnard College, where she also taught a popular course on civil rights and liberties. She serves and has served on many community and national boards, including the boards of New York's Trinity School, the National Council for Research on Women, and New York's Lawyers Alliance. It is my honor to turn the podium over to Kathy Rodgers, who will facilitate a thoughtful consideration of domestic violence, sexual assault, and the recent Supreme Court decision. Kathy.
Can I do this? Thank you very much, Harriet. I am delighted to be here this afternoon. It is an honor to address an organization with such a long and distinguished history of civic leadership. And I must say that I was truly impressed when I read that the club secretary way back in 1916 decreed that no mossbacks or drones are wanted. Well, I figured this must apply to speakers as well as members, and so I ran to my dictionary to find out what a mossback is. It turns out it's really not so hard to understand. It's just the opposite of a rolling stone. It's someone so stuck in place that he or she has become metaphorically encrusted with that slow-growing green plant life. So lest I be accused of being a mossback, let me not wait another minute to get to the central point of my remarks today. And it is this, that the federal government has the power and the duty to protect the basic civil rights of all of our citizens. And we have the power as citizens, we have the power and the duty to hold our elected leaders to that responsibility. Now, this seems uncontroversial enough, yet that simple truth is currently under a stealthy and steady siege. And I'm talking about the alarming revival of the so-called states' rights movement, a conservative crusade which is explicitly aimed at eroding the authority of the federal government to define and protect the civil rights of Americans. Now, this is not an offense to the citizens of this forward-looking state. I think we can all agree that state governments can, and they sometimes do, surpass the federal government in being progressive and innovative. Certainly Oregon has been a beacon for federal and state leaders alike on a number of important issues, such as health care and environmental protections, and places like this City Club have been leaders on the issue of violence against women. But from our country's founding to this day, the evidence is overwhelming. It's overwhelming that left to their own devices, most states will not advance the interests of those most at risk of unjust treatment. Just think about it. Many states did not desegregate their public institutions until the federal government made them do so. Most states did not give women the vote until the United States Constitution made them do so. And most states didn't provide educational equity to girls until the federal government made them do so. And that is why the federal government has played the necessary and appropriate role of setting minimum standards for fundamental civil rights, standards below which no state may be permitted to go. And as Harriet just said, this current furor over states' rights is not an academic debate about political philosophy. This is a real-life matter to all of us. As far as I'm concerned, this is nothing less than a struggle for the heart and soul of America, and a struggle for the future of our democracy. Let me tell you about two women whose lives are at the epicenter of this struggle, Maureen Valdez and Christy Brancala. Maureen Valdez lives in rural Oregon, and until recently, she worked for a trucking company and she drove a pilot car. And that's the car that goes out ahead on the highway and warns drivers that there's a wide load coming down the road. And it was a good job. It gave her decent pay, and it also allowed her to bring her 2 kids along in the back seat, which she needed to do because of the scarcity of child care in her area. And Maureen's ex-boyfriend worked for the same trucking company. And their relationship when they were together had been an abusive one. And one day, he brought that violence to work, an all too common experience for many women. He brought the violence to work by taking a hammer and smashing the headlights of her car. And he did that while the car was parked in the company parking lot. And he did it while Maureen and her 2 kids were sitting in the car. But that wasn't the end of it, because the company did nothing about that incident. Later, he told the dispatcher that he would kill Maureen if the company didn't fire her. So what do you think happened? The company fired Maureen, left her with no job, no money, no place to leave her kids while she tried to go out and look for a job. It just threw her from violence into poverty. Again, another pattern we're familiar with. Fortunately, Maureen found help with the Now Legal Defense and Education Fund and Oregon Legal Services. And we filed suit in federal district court under Title VII of the 1964 Civil Rights Act, which prohibits sex discrimination in employment. And when the court ruled that we did, in fact, have a legitimate claim, the company capitulated and Maureen received monetary damages. So federal rights and federal law worked for Maureen Valdez. And we had hoped that they would work for another client of ours, Christy Brancala, whom I assume many of you have heard about in the news in recent months. Christy was an 18-year-old first-year college student in her first week at school when she alleges she was raped by 2 college football players in her dormitory at Virginia Polytechnic. She went first to the school officials, and then she went to the police, and she got no meaningful remedy from either one. So Christy filed suit against the 2 men under the new civil rights remedy of the 1994 Violence Against Women Act. Now, with this provision, Congress recognized for the first time that gender-based violence violates women's civil rights and that it is a form of discrimination. But justice eluded Christy Brancala. First, she lost her case before the Fourth Circuit Court of Appeals, which is generally acknowledged to be at the center of states' rights activism. We then argued her case before the U.S. Supreme Court, and I should correct the record, it was my colleague who actually argued the case. And that happened last spring, and in May, to our great disappointment, the Supreme Court upheld the appeals court decision and found the civil rights remedy unconstitutional. It was a disappointment, yes, but it was not a surprise. The Supreme Court has in fact been taking the lead in efforts to limit the authority of the federal government and of Congress. And this trend began accelerating in the 90s. First, there was a 1992 decision that allowed states to do an end run around environmental regulations for nuclear waste disposal. And some of you may remember in 1995 a decision in which the Supreme Court struck down the Federal Gun-Free School Zones Act, ruling that it infringed on the police power of the state. And in 1997, the High Court barred from the federal government from requiring local authorities to implement the Brady Bill for gun control. And now this year, in 2 decisions, the Supreme Court has gutted civil rights protections for state employees under the Federal Fair Labor Standards Act and under the Federal Age Discrimination in Employment Act. These 2 rulings have affected 4.7 million employees across the country. And it's not insignificant that these include a disproportionate number of women and minorities. All told, in the last 5 years or so, the Supreme Court has held some 24 federal laws unconstitutional. That's an annual rate 4 times greater than what the court undid in the prior 2 centuries of its history. And Chief Justice Rehnquist has long been on public record about his desire to diminish federal powers and expand states' rights. And the brunt of these blows to federal power has fallen on those whose rights are most fragile to begin with: women, people of color, and the poor. Now, of course, the Supreme Court is not the only venue where the states' rights juggernaut is gathering steam. Lower courts, state legislatures, and county offices are also getting on board. Presidential candidates are touting the supposed virtues of less federal government. And then there's the organization that has the gall to call itself the Federalist Society, when its agenda is aggressively seeking to curb federal power. Now, I know you'll all remember from high school that the Federalists, at the time our Constitution was created, supported greater federal power over state power, else we would have no viable nation. And it's alarming how few people have even heard of the Federalist Society, whose influential affiliates include Supreme Court justices, U.S. senators, corporate presidents, and prominent law professors. And one of the things that I find most ironic about this movement is how often its proponents invoke the most hallowed of American values, individual rights. Indeed, the group that represented the defendants in Christy Broncalla's case calls itself the Center for Individual Rights. I would think it would be better called the Center for Individual Right-Wingers. And this organization's director, Michael Grieve, propounds a novel theory which he calls competitive federalism. Now, you can go look at your Constitution. You will not find anywhere in that Constitution the phrase competitive federalism. And what it is a free market model under which each state would construct a civil rights package and then market it to the public. And citizens would then shop around, and you would move to the state with the right rights, the rights you agree with. Now, I know this sounds improbable, and I really am not making it up. Mr. Grieve says that his model, and I quote this from the Wall Street Journal, quote, his model would allow citizens to sort themselves into the jurisdictions most to their liking, and only when Congress is barred from imposing one-size-fits-all solutions will the states have to compete for their citizens' business, talents, assets, and affections. Now, really, how many of us have the financial flexibility and the job mobility to shop for a state the way we'd shop for a pair of shoes, trying on different models until we finally find the right fit? And how many of us are likely to choose where we live, not because of family ties or community connections or our job, but because we have done intensive research on the civil rights of that state? So I think we need to get it straight. Our fundamental freedoms are not market commodities, and our governments are not merchants. And this dangerous movement is not about some neutral free market system that harms no one, nor about states' rights that benefit everyone. So we should call this phony federalism for what it really is: an aggressive attack on women and on all those who have yet to achieve full participation in our society, in our economy, and in our government. And this misguided notion that less government is somehow always better government isn't new, of course. In fact, if any of us were 250 years old or so, this viewpoint would have a very familiar ring to it. America has, in fact, been there and done that. And it was called the Articles of Confederation. And as a blueprint for a nation, the Articles were a failure. And that's why our founders created the Constitution of the United States. But even then, we were not yet a unified nation. We did not yet recognize and safeguard the fundamental liberties of individuals throughout the country. When Alexis de Tocqueville visited America in the early 19th century, he observed, and I quote, "The federal government scarcely ever interferes in any but foreign affairs, and the governments of the states in reality direct society in America." De Tocqueville called the resulting condition the tyranny of the majority, in which local powers were free to ignore the rights of the unpopular and the disenfranchised. So in the name of local sovereignty, today's states' rights advocates want to unravel our nation's history back to before the landmark civil rights laws of the 1960s, to before the New Deal, even to before the Civil War, to that time of de Tocqueville, when women weren't even mentioned in our Constitution, and African Americans were fractional, non-human beings. And unfortunately, this current crusade is making considerable progress, although I would call it regress. Let's return to Christy Brancala for a moment, because her case really goes to the very heart of what's wrong with the states' rights movement. When Congress passed the Violence Against Women Act in '94, it was after 4 years of intensive investigations and hearings, and it resulted in what Justice Souter actually called a mountain of evidence. And from that evidence, Congress concluded that violence against women is a national problem, and that it transcends economic, ethnic, and state barriers. So the act affirmed that women have a fundamental civil right to live free from gender-based violence, and that a patchwork of widely varying state laws was not providing adequate protection for that right. But in Christie's case, lawyers for her alleged rapists argued that Congress did not have the power to create the civil rights remedy. And what was the basis for their argument? That violence is a local matter for cities and states to deal with, not for the federal government. Well, I'll tell you, this sounds an awful lot to me like the pernicious argument that we've been fighting against for decades, that domestic violence is somehow just a private family matter, and that not even the local police should intervene. And it also sounds an awful lot like the arguments that we heard throughout the civil rights movement, that racial segregation was perfectly acceptable because it's simply part of the local historical tradition. Unfortunately, the Supreme Court concurred with this dangerous and disingenuous reasoning. Listen to these lines from Chief Justice Rehnquist's opinion in Christie's case, which is called Morrison versus United States. And I quote, "If the allegations here are true, no civilized system of justice could fail to provide her a remedy for the conduct of Respondent Morrison. But under our federal system, that remedy must be provided by the Commonwealth of Virginia and not by the United States," unquote. But in fact, our civilized system of justice could and did fail Christy Brancala. The local authorities failed her, the state university failed her, and now the United States Supreme Court has denied Christy Brancala and all women like her an opportunity for justice in the federal courts. And the High Court's ruling sends the chilling message that Congress has no authority to redress gender-based violence on a national level. And we can be sure that other forms of discrimination against women and against members of all marginalized groups are next in line for losing federal protection. And this trend could even hurt Maureen Valdez and thousands of other working women. Because we know that the states' rights crusaders have Title VII of the Civil Rights Act in their sights too, along with the Family and Medical Leave Act and the Equal Pay Act. All of these acts are aimed at giving women a fair shot at economic advancement without the interference of sex discrimination. Now, the proponents of states' rights engage in plenty of public hand-wringing over gender discrimination. But when it comes to using every possible tool at every level of government to eradicate these inequalities, they balk. Protecting the civil rights of individuals simply takes a backseat to preserving states' rights to deal with injustice as they see fit. And dealing with it as they see fit includes not dealing with it at all. But as historian Gary Wills said, states don't have rights, people do. And that is why Now Legal Defense and Education Fund is in the thick of this battle. For 30 years, Now Legal Defense has used the power of the law to define and defend women's rights. And we work at every level of government for systemic changes that will build equality and expand opportunity for all women and girls. And the victories that we have achieved really tell the history of the women's rights movement. We've won equal opportunity for women in the professions and non-traditional jobs. We've turned national attention to the issue of gender discrimination in education, including sexual harassment of girls. We've won historic cases on sexual harassment in employment, and we played a leading role in passing the 1994 Freedom of Access to Clinic Entrances Act. And we've done groundbreaking work on the intersection of violence and women's poverty, the case of Maureen Valdez being one of them. Today, we're mounting a campaign not only to end violence against women, but for affordable child care for all families and for economic justice for all women. We identify the cutting-edge priorities, and then our approach is strategic, big picture, and long range. You know, they say that patience is a virtue, and at Now Legal Defense, we are very virtuous. Our leadership on the Violence Against Women Act is typical of our approach. We helped to draft the legislation, and then we built the coalitions and grassroots advocacy that won its passage. We defended the legislation in the courts, and now we're taking the act back to the policy arena. It's critical to remember that the Supreme Court overturned the civil rights remedy, but the Violence Against Women Act is a comprehensive bill providing funding for all kinds of programs, such as local shelters and for the National Domestic Violence Hotline. And it also provides other kinds of new protections, such as interstate recognition of protection orders. So we're working very hard to make sure that this act gets reauthorized before the end of this session. In Christy Brancala's case, we did have a very real setback. But we are in this struggle for the long haul. And I don't just mean the Violence Against Women Act, but I mean against the broader struggle against the revival of states' rights and for the rights of Americans, no matter what state we live in. Now, while groups like Now Legal Defense are working through the Congress and the courts, what can you and I as individuals do? Well, the fact of the matter is there's a lot we can do. We can play an enormous role in shaping the terms of the debate and the outcome of this public debate. The recent erosion of civil rights has been stealthy, and most Americans are unaware of the movement's power and of the imminent danger it really poses. So let's start talking about it. Let's get it out on the table. And let's take it to our politicians. You can be sure that in this election year, they are going to listen to us. And I'm also sure that this group needs no reminding. There is simply no excuse for not voting. As the late Texas Congresswoman Barbara Jordan said, the stakes are too high for government to be a spectator sport. The genius of the American system of democracy is that it recognizes that some rights are too basic and too precious to be subject to the whims and dictates of the majority. Not everything in a democracy is up for grabs, and not everything can be subject to referendum or proposition. Our founders understood that powerful majorities often protect their own self-interest. Our Constitution does not permit them to do so if it means they are trampling on the rights of others. So it comes down to this. What is our vision for America? Is it one nation indivisible, a national community with a set of basic rights that apply no matter where you live? Now, if that is our vision, and I fervently believe that it is our vision, then we must reject the states' rights movement. And we must have the courage to voice our beliefs, to act on our beliefs, and to vote our beliefs. Because in the end, the federal government is not a necessary evil. It is a critical means to a necessary good. And with that, I thank you, and I'd like to open it up to questions. Is that what we're going to do?
Thank you, Kathy. That was really a very enlightening prelude to the question I have. When we did the domestic violence report, there were many discouraging tales we heard, and discouraging tales of what we do with our abused women and this kind of thing. So the VAWA, Violence Against Women's Act, was a ray of hope. And I understand from you and from what I read in the paper that that ray of hope is about to be extinguished. Is there anything that we can look forward to in the way of future legislation that will either take its place or will augment its effect on our lives?
Yes, there is. There's actually two things that are happening. The Violence Against Women Act was passed in 1994, and in the last 6 years, a little over $1.6 billion have gone out to every state in the country for programs for battered women, funding for programs in communities to help figure out together, you know, the police, the hospitals, the religious groups, the service providers together, figuring out how to deal with violence. So the most urgent thing that we have to do is reauthorize that act, and we have to do it this summer before Congress goes home for the election, because those provisions will fade away as of September 30th if the funding is not reauthorized. And I should tell you that the state of Oregon has received some $13 million under the act, and I think it would be good to continue having that money flow here. So let your Congress people and your senators know that you want to get this done. It's coming up now in both the Senate and the House. The second thing is that while we're working to reauthorize what we've already achieved, we are also working on another version of the Violence Against Women Act, which would expand the protections. It would take advantage of what we've learned in the past number of years about how to do things better. It would also give greater emphasis to some issues of sexual assault as well as domestic violence, and also try and put some money into programs for prevention of violence in the first place, education of young children, both girls and boys. It's wonderful to provide money to battered women's shelters, but the violence has already happened. We've got to find ways to stop it before it occurs.
My name is Dick Brownstein. I am a member of the club. If I may, I'll try to ask you two questions. One question is, how do you explain the overturning of the Violence Against Women Act with the recent decision on third-term abortions? How do those come together? It would seem that consistently the court should have ruled against the third-term abortion. Question two is, don't you believe that, and well, I should preface this by saying the City Club is a nonpartisan organization, but don't you think it's really critical in this election that the Supreme Court and its composition in the next 4 to 8 years be a very crucial issue for debate among the candidates?
Yeah, those are two great questions. The Violence Against Women Act civil rights remedy was overturned because the Supreme Court said it exceeded Congress's authority, explicit authority under the Commerce Clause and under the Equal Protection Act. So this Supreme Court, being consistent with its new jurisprudence, which says that the Commerce Clause is quite a bit more limited than the court had ruled in the prior 60 years since the New Deal. The overruling of the attempt to ban the DNX abortion procedure was based on a theory which is totally consistent with that. One, it's based on a theory that the law as enacted was too vague to be enforced. And the second reason was because they were following their precedent in not only Roe v. Wade, but the later case of Casey versus Planned Parenthood, in which the court said that the states do have an interest in protecting the fetus an increasing interest in protecting the fetus and the potential life of that fetus in the second term and the third term. But they can only do it if they are also protecting the life and the health of the mother. And that is where Justice O'Connor provided the fifth vote in that decision. And I should tell you that in the past, we had a 6-3 majority to protect the Roe v. Wade decision. It was a 5-4 majority in this case, and Justice O'Connor, who stayed strong on the issue that a woman's health has to be protected, also created a blueprint on how you might have a constitutional ban on the DNX procedure if you wrote the statute properly. We lost Justice Kennedy from that majority on the issue that he thought that this decision went too far in invading the state's interests in monitoring and perhaps prohibiting abortions. So the decisions are really very consistent. Now, the question about the Supreme Court justices. This is absolutely an important issue, and it doesn't matter what political party you're in. The next president is going to appoint between 2 and 4 justices on the Supreme Court. And right now, we don't have really a balanced court. We have 2 justices who are extreme conservatives and who are quite explicit on their agenda, one of which is to overturn Roe v. Wade, another of which is to overturn all of these civil rights statutes they think go beyond Congress's authority. Chief Justice Rehnquist is definitely in the states' rights camp. The other justices are really centrists. We don't have a liberal on the left to counterbalance the conservatives that we have on the right. I think throughout our history, the genius of it has been that we have tried to keep some kind of a balance in the Supreme Court. And it's not only important who's the president, it's important who's in the Senate, because they're the ones who advise and consent on the presidential nominees. And prior to the last 10 or 15 years, even when the president was not of the same party as the Senate, we did not have the kind of contentiousness and battles over ideology that we're now having for Supreme Court justices. And what we need to do is go back to the sensible, nonpartisan system where we are looking for strong candidates, people of judicial temperament, but not ideologues. Next question.
My name is Monroe Sweetland. I'm a member of the club. I want to ask you about a little event in history which seems to have died out of American recollection and energy. I think during the Carter administration was when it reached its peak. I may be wrong about that. But we had the enormous support for an equal rights amendment to the U.S. Constitution. I listened carefully to each of the points you raised, and I agree with you on your conclusions and attitude on every one that you mentioned. But wouldn't any one of these that you mentioned have been resolved if we'd had an equal rights amendment that explicitly and positively said what we tried to say, what was it, 50, 40 years ago? Is that issue dead? I hope not. I am Oregon's male member of the platform committee this year at the Democratic National Convention. So, and we meet in Cleveland in 2 weeks to work. There's already been one meeting, but a second meeting to work over the proposals for the platform. Now, I think you can poo-poo platforms and be indifferent about them and say that candidates always do whatever they want to anyway. But the fact of the matter is, many of the long steps of progress we've made in the past have originated in party platforms and have been adopted or not as candidates felt. But wouldn't it be a weapon for us? And wouldn't most of these battles that you waged so energetically before the Supreme Court be resolved or nearly resolved if we had a positive statement? Do you think we can revive the Equal Rights Amendment? I think there is increased sentiment for equal rights as a theory, but we sure haven't got there through the present procedures.
Well, no, it was a very long battle. It won't surprise you to know that I agree with you. I think we ought to have an Equal Rights Amendment, and it hasn't died. There is consistently an effort to reintroduce the Equal Rights Amendment in Congress. There is right now a theory and an effort out there that, we only lost by 3 states in the end, and it was on a short deadline. And there is a theory out there that, in fact, there was no deadline. And if we could get 3 states to vote for the Equal Rights Amendment, we'd have a real argument for saying that, in fact, it was approved and that it should be part of our Constitution. It took 72 years from the Seneca Falls Convention in 1849 to get women the vote, which we finally got in 1920. That's why we have to be patient. That's why we're so virtuous. It takes a long time to overturn millennia of history and culture. It would make a difference if we had this in the Constitution. First of all, finally, women would be recognized as full-blown citizens of the United States, and that everything would have to be looked at from the point of view of how it affects women, and not just from this so-called neutral stand of citizens or the people. You would have to analyze everything in terms of how it affects women. And the problem with statutes like the Equal Pay Act or the Family and Medical Leave Act is that they can be overturned and they can be changed with the next Congress. When you finally get something into the Constitution, it is much more permanent, I guess with the exception of the Prohibition Amendment. So it is really very important to have that constitutional recognition of women's equal status. Yes.
Good afternoon. Diane Lynn, City Club member. I serve on the Multnomah County Commission, one of Pauling's predecessors or successors. We're working very hard on domestic violence issues and have people like Mary Souther Wyatt Judge and many other state legislators working with us to help prepare a package here in Oregon. We hope we can make some great progress on that this session, and your legal analysis today was very helpful to that. I hope that there's times and places and forums for local elected officials and business leaders to express our support for the federal government playing this critical role, and we hope we can stay in contact with you about that. My question really is, unfortunately, I was terribly disturbed by the incident in Central Park, and I just wanted to have your quick response from a legal perspective if there's any remedy for the women that were involved in that incident and kind of what that says about where we are in terms of public perception of this particular problem.
Well, there's 2 things in your question, and I should just point out that with respect to the Violence Against Women Act and support from local and state officials for the federal role in that act, you should know that we had well over 2/3 of the state attorneys general from across the country testifying in support of the act. We had support from police departments all over the country. And the reason being that they recognize what a problem violence against women is, and while they are making their own efforts, they need help. And that's what they wanted. They wanted a federal-state partnership. We ought to be able to do that in this country. So it's very important to note that this act did not in any way infringe upon states. It was only helping and providing more for them to deal with this problem. The second question, the incident in Central Park in New York, for those of you who may not have heard about it, there was a big parade that we have every summer in June, and it goes right by Central Park. And the park is busy and used by people in the summer. It's just filled with people. And at the end of this parade, gangs of men began chasing women. They were assaulting them, they were hitting them, throwing water and ice on them, disrobing them, tearing their clothes off, grabbing their genitals. And all this was happening at about 5 or 6 o'clock in the afternoon in broad daylight at the south end of Central Park, which is quite near the Plaza Hotel. And there was no police response to speak of. There was one couple, a French couple, newly married. The police seemed to take the husband's testimony credibly, but otherwise there was virtually no response. And it went public because one of the victims was a woman who was used to doing radio and television. And so she took it to the press, and then we saw the videos of what really happened. What this tells you is how deep the cultural habits are which say women are objects, and when we want to have fun or when we want to exercise control, who do we target? We target women. And that is still very much alive in our society. And it also tells you that even in places like New York City, where we had one of the first domestic violence units in the police department, we have a city prosecutor who's been in the forefront of this battle and changing the laws on rape. Even in New York City, we still have a long way to go in educating our police. And, you know, while the press has focused on the police, I'm disturbed by the public. This was in front of literally scores of people, and nobody tried to stop it. Everybody just watched, including the guy with the videotape. But I guess, you know, that turned out to be very useful. So I think it's something that we really, really have to do some soul searching about, and it's too easy to just say that the police didn't respond.
Corleen Kraft, City Club member. We in Oregon, as you probably know, are becoming experts on states' rights because after our Assisted Suicide Act, it's only the right of the state if everybody else agrees with it, it would appear. But my question is this: since you had such overwhelming support for the Violence Against Women's Act, and it went to the Supreme Court said that it, and I think this was only one of a few decisions where they made this same ruling, that the federal government did not have the right to pass laws such as that. What can we do? I mean, I understand that we can now try to get it refunded before the end of this session. But if you can't go to your legislators and have the acts passed without having them struck down by the Supreme Court, what other recourse is there?
Well, I think there's really two parts to the answer to that question. It was just the civil rights remedy which was struck down by the Supreme Court, not the rest of the act. But in terms of that, which was really very innovative in recognizing that violence against women is discrimination and a violation of our civil rights, states can pass their own laws to do the same thing. Most states do have laws which permit civil suits against abusers or rapists for physical assault. Some states have some remedies where you can sue the city or something if there was negligence in failing to prevent an abuser, perhaps an abuser that's violating a protection order. So states can pass statutes. We're looking at what kind of a federal remedy that we might invent that would meet the requirements of this Supreme Court decision. And if there is some way to say, okay, they say that this has to have a more direct link, a more direct nexus to commercial activity. And they said that this violence was just individual, private activity, and that is a criminal activity that the states are supposed to deal with. So we're looking for ways to at least capture those occasions where there is some sort of commercial activity involved, as we did in the civil rights cases with hotels and restaurants and so on. When someone discriminated on the basis of race there was kind of a recognition, well, automatically that has a commercial nexus. So we might be able to go after employers or workplaces. Whatever we come up with is going to be more limited than the original civil rights remedy. Then there's no question about that.
John Leeper, City Club member, 2 questions. First, did the Supreme Court ruling on the Broncala issue void out the whole Violence Against Women Act or only that portion of it? My second question is, looking at states' right on a broader context, we in Oregon, I think, have got a problem in that we as a state have initiated action, and Congress is trying now to pass legislation concerning the Death with Dignity Act. In many ways, that is a states' right issue, and how is that reconciled with the comments that you stated earlier?
Okay, on the first question, it was only the civil rights remedy that was overturned. The rest of the Violence Against Women Act is alive and well until September 30th. It will only continue to thrive if we get it reauthorized this summer. And that we can do through Congress. You raise a very interesting question about this balance between congressional authority and state authority. And there is no question that I've always had this balance between states and federal governments, and that sometimes states will go further than the federal government in recognizing rights or in providing new remedies for these rights and new protections for these rights. That has been, it has been part of our system that often it's a state that will lead the way on something like that. But for the most part, it's the federal government that has pulled along the majority of the states who lag way behind. And I gave you some examples, such as educational equity for girls. I think that it's a close call whether Congress can deal with this death with dignity issue, which and whether it can do so constitutionally. And you know, I don't know how that's going to come out in the end, because that is an example of states trying to move something forward. But I don't think the story is over yet. That issue is not resolved.
Hi, Kathy. This is a quick procedural question. My name is Susan Oliver, and I'm a member. You talk about needing to reauthorize the Violence Against Women Act by September 30th. This kind of concerns me, and maybe there are other political naivets out there like me. How often do we have to renew this thing every year? Is this like a subscription to my favorite magazine that I have to keep tabs on? Or my City Club membership? Am I going to get a bill? What other acts are there out there that I need to be watching out for? This seems to be a little bit much to ask of all the citizens to keep track of all the time. What's going on?
Well, that's a terrific question, because most legislation does have to be reauthorized regularly. And that includes this bill, which is on a 5-year reauthorization schedule. All the major legislation that we have for education at the secondary, elementary, and college level has to regularly be reauthorized, or the funding will disappear. And an awful lot happens in that reauthorization process. One of the things that you may not be aware of is that for a number of years there's been a major effort to gut Title IX, which is the provision that prohibits sex discrimination in education. It has come up year after year, and it's just come up again, and the Senate voted a compromise which will permit experimentation with single-sex programs in public schools. And Title IX now prohibits all single-sex programs in public schools, except for things like the girls' chorus and the boys' chorus, or some sports activities. But everything else has to be coeducational. And underlying this logic was that all it needs to be is comparable. You can have a single-sex program if they are comparable, not equal. Now, you may remember the Virginia Military Institute case, where comparable to this military education was 1 hour a week of a leadership seminar at another women's college in the area. So it's happening all the time, and you know, the best thing we can do is we try and get the information out to you folks. And you can look at our new website, which is a news service, Women's E-News, www.womensenews.org. And we're trying to get out the stories that you don't see typically in the mainstream media, but you can get them directly. And we're hoping that the media will pick them up. We're going to be the new AP on women's news. I see some movement over here.
One last question from the floor. Where should we draw the line between states' rights and federal power, or are you saying that you oppose all states' rights?
No, I absolutely do not oppose all states' rights. What I am arguing for is that we need recognition of civil rights and protections for those rights at every level of government. And that includes, very importantly, the federal government. It has a major role to play to make sure that there are minimum standards across the country. That's what the current fight is about. It's trying to push the federal government out of this effort altogether. I think it's terrific if states want to go even further and create more rights, just so long as we all have certain basic minimum rights no matter where we live.
Kathy, on behalf of City Club and our members who are not here and others who are both watching and listening, thank you very much for your comments. It certainly does reinforce the need for our ongoing vigilance on these and other matters. I've been trying to think of an appropriate metaphor that this program is on Bastille Day, something about imperial judiciary. I'll figure it out before the day's end. We're adjourned.